The broadcast is now starting. All attendees are in listen-only mode.
Hey there, this is David Perdue from MyNAMS.com and the Novice to Advanced Marketing System, and I hope you guys can see the screen. We have the please stand by slide still up, but I'm sure that Alan and Chip are going to jump in here with their presentation first slide as soon as we get started in a few minutes. First off, I wanted to say I'm welcome to all of you folks who are coming in. People are just pouring in for this, and there's a really good reason for that. Messing around with the FTC is not a good thing. Chip Cooper, the internet attorney and the guy that I rely on for all things legal online, has convinced me years ago when he first came into my line of sight that if we weren't careful, we could all lose everything we had as an online business and not even know what we were doing wrong. So I'd love to have Chip around, and Alan Cutts is with him today. Alan is Chip's business partner in FTC Guardian, and they're both going to walk us through a lot of the horror stories that you hear about the online business world as far as FTC and other legal entities. So Chip and Alan, thanks for coming, guys. Thanks for being here. I really appreciate this. I know this is an incredibly important topic.
Thank you. Thank you very much. I just want to start with first, thank you for everybody for showing up. We've got so many people on there, and if you have questions during the webinar, don't be afraid to enter your questions in the chat box. I'll do my best to keep up to date with the questions. And worst case scenario is at the end, if we just can't get to all the questions, just send an email to support@FTCGuardian.com, and Chip and I will do the best that we can to answer your questions. I want to start with just right now is probably a good time, because I'm going to turn it over to Chip in a moment. But if you can, close the door to your office. Just turn your cell phone off or do whatever. But spend a little bit of time focusing on this, because what we're going to focus on is your ability to grow your business and do it in a way that is not only ethical, which I'm absolutely sure every one of you are doing, but you're also compliant. And there is a big difference. And I've learned this through Chip. Chip and I have been good friends for a couple of years now, and it's one of the things that I've really, the lingo that I picked up is there's a big difference between being ethical, as most of us are as online marketers. I know there are some unethical guys out there, or guys and gals on there, but most of us that are really trying to make a living online, we are ethical. We're doing what we believe is ethical, but we're not necessarily compliant as it relates to the FTC, or as Chip might explain later, the 26 little FTCs that are out there. Or you may not be compliant with Google. You may not be compliant with Bing. You may not be compliant with Facebook if you're doing advertising with those networks. So it's going to go a long ways. So let me just turn this over to Chip, and Chip, I'm going to turn the screen share over to you, and if you will pop your screen in there.
Okay, I'm doing that, I think.
You are. I see it, Chip. That's great.
You can see that. Okay.
Everything works. How about that?
Great. Thank you very much, David and Alan, for those kind words and that introduction. And so let's go ahead and get started here. And you can see on this initial slide the title, Why These Tragic Legal War Stories Could Get Your Bank Accounts Frozen by the FTC, and what you can do to avoid this happening to you. So before we start, what are war stories? Well, I think David sort of let us know. They are simply lawsuits that have been brought by the Federal Trade Commission against online marketers just like you. And they were the result of some very tragic legal mistakes or legal omissions or lack of compliance. And think about this before we start. Do you think these people really intended to violate the law? I'm pretty sure they didn't. And to use an old cliche, they just didn't know what they didn't know. And that resulted in a failure to build in legal compliance strategies into their marketing strategies and plans. They probably, as Alan suggested, just thought being ethical was enough, or they just decided maybe to wing it. In any event, there were some serious mistakes leading to some very serious war stories that we can learn some valuable lessons from in this call. And in the interest of full disclosure, some of these war stories are a little scary, but you shouldn't worry, because at the end of the presentation, I'm going to make you an offer that'll make for a very simple and easy solution. So before we proceed any further, I'm going to point out several takeaways at the very beginning. I want to make sure that you get these before we jump into some of the detail. And if I had to find or indicate one takeaway that would be the most important and the most single, I guess, overarching takeaway, would be this one. And I'll ask you to write this one down. In fact, I'm not going to ask you to write down more than, I think, 2 more. So, and I'll tell you why in a minute, because we've got a great resource for you that will cause you not to have to write this stuff down. But this one's so important, write it down. Successful marketing strategies reflect built-in legal strategies. Very significant, so write that down. We'll come back to it in a little while. And before we get into this full speed, there's some housekeeping announcements. This information in this presentation is presented for informational purposes only. It's not to be construed as legal advice, and certainly no attorney-client relationship is created, and we're not endorsed by the Federal Trade Commission. All right, let me introduce you to your 800-pound gorilla. So what if I told you that you're really not alone as you work on your online business, that there's an 800-pound gorilla in the room watching you every time you write marketing copy or sales page or a squeeze page? Well, I'm sure you figured out by now that we're talking about a metaphor, that the gorilla is really a metaphor for the FTC. And of course, you'd be correct if you figured that one out. And you've probably heard of this metaphor a number of times before this presentation. And if you think about it, it's always used, or most often used, in a situation where it represents worry and concern. You know this thing is in the room there, right? But you'd rather just ignore it. But tonight, I'm not going to ignore the gorilla. In fact, it's going to be the focus of the presentation. And at the end, you'll know a lot more about this gorilla than you do now, how he works, how he affects you and the way you operate your business. And more important, I'm going to show you and explain to you how easy it is to tame this gorilla so that you can operate your business worry-free. Now, here's the offer that I was alluding to just a minute ago, and that is this is a copy, or not a copy, but a shot of the cover of my latest book, just published a few months ago, 7 Tragic Legal Mistakes That Can Get Your Bank Accounts Frozen by the FTC. And a lot of the information in here is more in detail than what we're able to cover tonight. And you can get a free copy of this if you stay on to the end of the presentation. Alan Cutts at the end of the presentation will give you all the information that you need to access this book. So by all means, stay tuned to the very end, and you'll get a lot of additional information. And for this reason, you don't really need to take a lot of notes in this presentation. All right, a little bit about my background so you'll know where I'm coming from. I'm a full-time practicing attorney for over 30 years. I am of counsel to the Atlanta firm of Jones & Haley, and my area of practice in the law firm is the areas of internet law, software as a service known as SaaS, software and intellectual property law. And I've also served as an adjunct professor of software law at Wake Forest University School of Law for 20 years. And I've authored 4 books in the fields of software law and internet law, and you just saw the cover shot for the most recent one. Now, we are a small boutique firm focusing on business clients, and we were very fortunate in 2011 to be named one of Atlanta's top law firms. And this is a a clip of the plaque that we received for that. Now, drilling down a little bit more into what we'll cover in the presentation, number one, we're going to cover why the FTC is now going after the little guys instead of the big guys that they used to go after primarily, and why, if you're the typical little guy, you should be worried about it. Secondly, what it's like to get sued by the FTC. Now, this is not a pleasant thing to think about, but I'm going to walk you step by step in exactly what's involved in an FTC lawsuit, how your bank accounts and personal assets can be frozen and lost, and then finally we're going to drill down in more detail into 2 real-life cases as examples of people who didn't think they were at risk but who instead got nailed by the FTC and why it could happen to you. So here are some more of the takeaways I mentioned at the outset, and the second one I would like you to write down is in blue at the top, the first bullet. So if you would, just write this down because it's extremely important. If you sell to consumers, and we consider people who work at home to be consumers, so if you sell to consumers located in the United States, anywhere, any state, you're personally liable for deceptive marketing practices regardless of where you're located worldwide. So you can be in Europe selling into the U.S. to consumers here, and you are now liable personally for deceptive marketing practices. So be sure to write that down. The remainder of these takeaways really sort of support that general idea. And by being personally liable, it means that you risk losing personal assets, and virtually all of them, including your family assets and bank accounts. And you need to know that cleverly worded disclaimers, which a lot of people mistakenly think will save them and protect them, really won't. Knowing the rules of the road about how to operate your business in compliance will. And you need to know that asset protection schemes are utterly useless, meaning that if you operate in a corporation or an LLC or a whole nest of these entities, the FTC can penetrate those like a hot knife through butter. They won't protect you. And your ideas of due process of law are probably going to be all wrong regarding FTC claims. And you know that you're not legal in a number of areas probably, or after this presentation you'll probably be a little bit more aware, but you need to know that ignorance is no excuse. The only defense, by the way, is to learn how to operate your business legally and to simply do it. And then this last one in blue is the last one I'm going to ask you to write down, because this is the last of the 3 big ones. Set it and forget it is an open invitation to a massive FTC claim, and that means simply putting up a terms of use, a privacy policy, and a few disclaimers and then forgetting about it is almost guaranteed to get you into some serious trouble. There's more to it than that, and we'll explain what that is and how easy it can be a little bit later. And also, it's important to understand that the FTC is a major factor to consider in operating any online business, and that's why we focus on it primarily in FTC Guardian. But there's some other things that are extremely important as well, and we're going to introduce you briefly to some of those resources. Intellectual property protection. If you're the typical online marketer, you create coaching programs, written documents, all sorts of things that involve copyrights, possibly trade secrets, and also how to limit your liability. So there's some very important things to operating your business legally that aren't strictly FTC related, and we're going to give you some insight into some resources that can help you there as well. Okay, so let's get into this trend about how the FTC is now going after the little guys, and there are really 3 phases that'll explain how this works and how it has developed and evolved over time. The first one is a period that I call the Wild Wild West, and it began when the Internet became a commercial reality in the mid-90s, and it continued through 2008. There was very little regulation, very little activity legally by the Federal Trade Commission. The word was, let's see how this entrepreneurial network plays out. Let's don't interfere with it. And there was a lot of scamming going on in the latter part of that period of the Wild Wild West. And believe me, it's over, and it'll never be the same. Because beginning in 2009, we have the beginning of phase 2, which I call the tsunami. And that's where we have literally a tsunami of new laws and regulations affecting online businesses, and a lot of very aggressive stepped-up enforcement by the FTC. But the prime targets during this period were the big guys, Google, Facebook, Twitter, and some others, not the little guys like most of us. But beginning in 2014, I've seen the beginning of the next phase, which is what I call the FTC drill down, meaning that the FTC is now focusing on the smaller so-called little guys. And you see with these bullet points here the types of things, or just some of them, that the FTC is looking at: unsubstantiated claims, testimonials, membership, work at home, affiliate marketers, big headache for the FTC, coaching programs, privacy policy statements. Now, a lot of what you see here in these bullets is going to be covered in much more detail in the book. That's going to be the free offer if you hang on to the end of the presentation. So be sure to do that. A lot of this will be covered in much more detail in that book. All right, now we get to the, I guess it's the most interesting part. I mean, some people have told me that. They want to know what it's like to be sued by the FTC. So here we go, step by step. And to begin the process, you need to understand that even if you're a so-called little guy, you really can't hide from the FTC the way the person toward the back of the row here in this slide is trying to hide. Now, the guy in the front row with the bullet on the target on his head is probably a larger player in the online marketing area. He's probably generated some complaints that have found their way through the funnels, which you'll see in just a minute, to the Federal Trade Commission. The Federal Trade Commission might be considering bringing a lawsuit, but, and this is extremely important, the FTC, not only looks to the guy that's, generating complaints and doing some things that probably shouldn't be done, but then they look at the category of marketers that are doing similar things, right? They've done this in the weight loss space, with membership websites, with work at home, with a whole bunch of other categories. So even though you're not a larger player, if you're back there near the back row, you can be part of the group that is targeted because of something the guy on the front row is doing. So you really cannot hide from the Federal Trade Commission. Now, in order to build a case, one thing that the FTC does is simply go online and look at your website. And in the fall of 2014, the FTC sent out over 60 letters, not that many, but still 60 or so, to online marketers saying, we're looking at your website and we think we see a number of violations, and we don't see how in the world you can substantiate some of your ad claims, and we strongly recommend that you correct this. So they can see you 24/7. And certainly keep an eye on what you're doing. And part of their investigation is direct, as this little guy is doing. But the way that they really get down to the nitty-gritty is through marketing funnels, right? They use some of the same tactics that online marketers use, and this is the prime funnel. It is a complaint form on the FTC website. If you Google FTC complaint, it will come up as the #1 hit, and it's much more comprehensive than this cover page might indicate. Very comprehensive. They're asking for lots of information. They're asking your customers and others who are familiar with your website to complain about it, and in great detail. And this is one of the ways they derive and collect information that they can then use to build a case against you or me or some other online marketer. They also have, you're probably not aware of this, a Facebook account and page. This is a clip of it, and you see down in the lower right-hand corner they have a link that says reviews. Now, there's not a lot of high-level, I've been there several times and read some of that stuff. A lot of it's sort of gripe in nature, but they do check it out. And if there's a complaint that looks like it's significant, they'll follow up on it. So this is the second type of funnel that they use to collect information against marketers who are taking advantage of consumers, right? That's what the FTC does. But this is the big source of information, affiliate networks. And as an online marketer, you're not the only type of entity that uses affiliate networks. They rely on news articles, blog posts. They get a lot of complaints through the Better Business Bureau. Some people haven't heard of the Federal Trade Commission complaint form, but everybody has heard of the Better Business Bureau. They make complaints there, and then those are funneled in many cases to the Federal Trade Commission. There is a division of the Better Business Bureau called the National Advertising Division, operating under the acronym NAD, N-A-D, and they actually review websites and online marketers who appear to be involved in deceptive practices. And a lot of those reviews are then sent to the Better Business Bureau. And then, of course, there are advocacy groups, and even competitors can file complaints. And then, as Alan mentioned in the outset, there are 28 states that have what are known as little FTC acts. Now, every state has consumer protection laws, right? But 28 of those actually have statutes that very closely are modeled after the Federal Trade Commission Act or the FTC Act, and those are called little FTC acts. So you have the state attorney general there. In fact, the state attorney general in New York sued Donald Trump University for the sale of coaching programs a couple of years ago. So they also bring separate actions, very similar to the Federal Trade Commission. They also refer complaints. So there's a vast affiliate network that feeds a lot of complaint information to the Federal Trade Commission. So when they start getting complaints, which is their stock in trade, by the way, that's what they consider traffic, right? Then what do they do with it? That's the next question. They can probably, in most cases, they'll send an informal letter asking for information about how you substantiate some of your ad claims, for example. And if they don't like the way you answer, or if you're just not cooperative, the next step would be a civil investigative demand, or a CID, which is essentially a subpoena. And what you see here is a clip of the third phase in the CID process. Step one is they file this thing and they ask for tons of information about your marketing, right? And then if you're the recipient of this, as this company, as you can see here in the matter of Jerk LLC, I think if I were Jerk, I wouldn't have named my company Jerk, right? It just seems like a classic target that the FTC might want to go after. But anyway, Jerk's attorney would then respond with a petition to quash, which is a fancy legal term to say you're on a fishing expedition, you're asking for too much information, it's too broad, and then the Federal Trade Commission will, in most cases, deny it. And that's what you see, an order denying the petition to quash. So then the big step is the lawsuit is filed now, because the information's been collected, it's been analyzed, and a decision has been made to file a lawsuit. And here's what the top half of the complaint looks like. And you can see here, this one brought against a so-called little guy, Apply Knowledge. They were selling money-making opportunities and upsells to coaching programs. And you see on the right column something that should make the hair stand up on the back of your neck, and that is a temporary restraining order, an asset freeze, and the appointment of a temporary receiver. So let's look at another clip taken from a different case, a different order of court from a different case, and this one is from a company called Online Entrepreneur. And this is another so-called little guy. They were selling money-making opportunities, including websites with upsells. And they were nailed for $2,900,000, almost $3 million. And one of the interesting things here is that these were so-called little guys, and they couldn't come up with the $2.9 million, right? They couldn't do it. And so what the FTC does when little guys are involved, Microsoft or Google just writes a check for $20 million, it's pocket change, right? But if you're a little guy in the online marketing world, and you get a $2,900,000 judgment against you, then what do? Well, what they did was they made the individual officers and owners of this company sign affidavits under oath that they had identified all of their personal assets. And so then they said, if you surrender these assets, including personal bank accounts that are specified, real estate, in this case, the wife's diamond necklace, a watch, even a personal computer, if you do all of that so that it can be liquidated into cash, then they will suspend the remainder of the judgment. But if they ever find out that you were lying and were trying to hide assets, then the entire $2,900,000 then comes back into play. So that's what happened to these unfortunate guys. And you see here an asset freeze clip. And if you look sort of in the middle to the right side, you see that it relates to any asset, which could be real estate, bank accounts, etc. And you see the language restrained and enjoined from, assigning, concealing, converting, basically doing anything with any asset. So that's the language of an asset freeze. That's what it looks like. Hope you never see one, right? And then also in the same case, a receiver was appointed. Now the receiver is a completely independent party appointed by the court who goes in and takes over your business. You're shown the door, and the receiver assumes full control, as you see in Part A. And in Part B, the receiver is ordered to take custody and control of all the assets and to work through them and report back to the court. So if that doesn't get your attention, nothing will. So that's what happened in the online entrepreneur case. And then the final step in the process is, once all of this has happened, the FTC typically provides a settlement demand so that the case would be concluded based on agreement or settlement agreement. However, the settlement demand is non-negotiable. I mean, it's either take it or leave it. And in another case involving a company called Commerce Planet, there were a number of individuals who were working in the company. One was a guy named Aaron Gravitz, and he settled for a little less than $200,000, $192,000. But then there was a guy, Charles Gugliuzza, I believe is the correct pronunciation, who refused to settle. And it just so happens Charles was a lawyer and thought he could do battle with the Federal Trade Commission, which was a terrible, terrible mistake. He fought and lost and ended up with a judgment of $18.2 million, which is close to about 10 times what Gravitz settled for. So one of the lessons here is don't litigate with the U.S. government. I mean, they've got unlimited resources just about, and there's no way that you're going to win. So there was the $18.2 million judgment, 20 years of compliance reporting, and the judgment was affirmed after it was appealed by the Ninth Circuit back in 2012. So you're almost always going to be ahead of the game to take the non-negotiable settlement offer. And then the final order, which is the result of agreeing to the non-negotiable demand, is almost always in three parts, as indicated here. There's always a permanent ban or an injunction against what you were doing. Whatever was complained about in the complaint and lawsuit, you're going to be banned from. And then the second one is the payment of money, and the technical legal term is equitable restitution. You would think of it as a fine, and it involves, in most cases, huge numbers, and it reaches your personal assets. The Federal Trade Commission has massive powers to go after your family assets, and by the way, when they get this judgment against you, it's not dischargeable in bankruptcy. So you can't just run out, file personal bankruptcy, and be done with it. It's considered fraud, which is not dischargeable. So you've got to live with this thing. And then the last piece of the typical order is compliance reporting, and the period is usually from 10 to 20 years. And what the FTC wants to do is to stay very close to you in terms of contact. They want to know all your contact information. It's got to be continually updated, all of your business activities, where you're working, what you're doing, and all sorts of record keeping about, particularly if you're involved in any type of online marketing after that. So the final order here is not only just a big number that you're stuck with in terms of financial liability, but also you've got a permanent injunction on you so that you're not going to be able to work in some of the areas you're more familiar with, and you've got 10 to 20 years of compliance reporting, which is just a terrible nightmare in terms of detail. Okay, let's talk about one of the more detailed cases, and there are two of them. This is the first one. We just finished the steps involved in what it's like to be sued, and in that process, you recall, I touched on maybe 3 or possibly 4 cases as I recall, but we're going to talk about 2 cases now in a little bit more detail. The first one is Equinity Interactive, and they were involved in free offers. Now, if you're typical, you do make free offers, right? Typically in list building, and that would typically be on a squeeze page where you're offering some kind of free ebook or whatever to sign up to get on your mailing list. So listen carefully to this one. In this particular case, I call it a free offers type of case, also involving robocalls. The defendant was Equinity Interactive, and particularly an individual named Gary Jonas, lives in Florida. The defendant's marketing strategy was fairly straightforward. They offered free products. However, in order to get the free product, you had to provide a massive amount of personal information, including phone numbers, which they then used to make robocalls to sell a whole bunch of stuff to you. So that was what was going on, and the FTC alleged that, among other things, that the offers, so-called free offers, were not really free, and therefore they were deceptive and actionable under the Federal Trade Commission Act, the FTC Act. So you see a couple of examples of their offers in the first 2 bullets: test a new iPad, also free $1,000 Walmart gift card. But you also see in the 3rd bullet the types of information that were required to be given up in order to get anything free. In fact, a lot of people didn't really get anything free. Some of them were actually required to spend money even though they offer promised free. So the FTC said it's really not free because you're having to pay for it with a lot of very valuable personal information. So it's deceptive, and we're going to bring a lawsuit. So there was a settlement. They were permanently banned from illegal telemarketing because they followed up with that. They were nailed jointly and severally, personally, for $7,800,000. And in this case, the defendants had a source of income that would satisfy the judgment if the FTC would allow them to make the payments in installments, which they did. However, the FTC, is pretty smart. They said we want a mortgage on Gary Jonas's condo in Boca Raton, Florida, to secure the remaining balance here. The FTC, pretty good business people here, and so they got paid what they were entitled to under the order. Now, here is an example of some issues that we've discussed in a hangout for members, and I'll give you more information about that in a few minutes. We're not going to go through it here because it takes a little more time than we have available, but what the point I want to make is that in these hangouts that we'll describe in a few minutes in a little more detail, we go into a recent case or some recent development, and then we take the lessons and apply it to what our members actually do. So what would you learn from this case involving free offers that are not really free? Well, here are some alternatives that you can actually put on your opt-in pages and probably not be liable to the Federal Trade Commission. We went through all of those and made recommendations. All right, the second of the 2 cases that we're going into more detail on is the Snapchat case. And this is a privacy policy case, which obviously not only, do we have this free offer case we just finished talking about that probably applies to everybody on this call. This one does as well. We all have privacy policies because we all collect personal information, and when you do, then you're required to have a privacy policy. And Snapchat had an interesting marketing strategy. They have a mobile app that allowed users to take pictures or videos that they called snaps. And then the person who took the snap could then send it, email it, or text it to friends, right? And the sender could also determine the time frame during which the recipient could view the snap, and then the snap would, as promised, disappear forever, close quote, close quote, after the time specified. So the idea was, if you were out with your friends and you were at a bar or a party and you had one or two or maybe three too many and you're having a great time and we're taking a selfie with you and 4 or 5 people with their arms around you just having a great time, you could then send the picture to a couple of 3 other friends, right, knowing that the snap would disappear forever and your employer wouldn't be able to see it, you know, the next day. And wonder why you were carrying on like that. Pretty neat idea. The problem was the claim for the snap disappearing forever was really false. Under certain circumstances it would, but under others it would not. Right? So when you make this claim and it's false, it's deceptive and it's actionable for an FTC claim. Also, they collected location-based information, which is required to be disclosed in your privacy policy. They didn't do it. They also collected other categories of personal information which were not detailed in the privacy policy, which is required. All of this is deceptive. And they failed to provide reasonable security measures to protect this information. So the FTC brought the lawsuit making these allegations among a few others. And the result was, and this, oddly enough, there was no fine levied in this case, but Snapchat was permanently banned from engaging in these practices that were regarded as deceptive. They were ordered to undertake an extremely comprehensive privacy program, and they were burdened with 20 years of compliance reporting. So this is another case that really is very much applicable to just about all of us as online marketers. And here are a couple of 3 takeaways from it that we'll go into briefly. The first one is you need to remember this. The Federal Trade Commission regards statements and assurances that you give in your privacy policy as almost like enforceable contractual promises. So the rule is, do what you'll say you do and don't do what you say you want. So if you say, for example, that these snaps will disappear forever, by George, they better disappear. If they don't, it's deceptive and you haven't honored your privacy policies. So also, and this is what trips up a lot of people, and we're going to see a lot more cases on this in the near future. Not only are there categories of information that need to be collected, but here's where we're going to see some action, I know, in the near future with the Federal Trade Commission, and that is in the area involving remarketing or interest-based ads, where customers or prospects' browsing history is tracked over time and over different websites, and then when they go to another website, they're served up an ad that's based on interest that they displayed in their browsing history. And this whole idea of remarketing, retargeting, interest-based ads is a very controversial subject because it's essentially been outlawed in Europe. But in the United States, the Federal Trade Commission is very reluctant to do that because a number of consumers, and I'm one of them, by the way, I like to see ads that are targeted to my interests, right? So I'm not too worried about the privacy implications. But there are a lot of people who are freaking out over this. And so the Federal Trade Commission, who's primarily involved in protecting consumers, sees a division here in the United States among consumers, so between consumers who either like this or don't like it. And so the way they regulate it is to require marketers who participate to provide disclosures. And so your privacy policy needs to have a number of disclosures, and a lot of this is indicated in the book, but the actual disclosures themselves are in the documents that we have on our website. And you need to know that you can not only get in trouble with the Federal Trade Commission without making, if you fail to make these required disclosures for remarketing, but you can also be banned from the network that sponsors these platforms, Google and Facebook primarily. So because the remarketing is so effective in terms of increased conversions, this is extremely interesting. We've had a number of hangouts devoted to this on how to comply and how our privacy policy provides the required disclosures, that sort of thing. So very important to be aware of this. Okay, so we've seen a lot of horror stories, war stories, horror stories, whatever, and you're probably a little concerned about it if you're typical. And I would just like to say, first of all, it's not your fault, for goodness sakes. I believe that most of you, if not all of you, are ethical. In fact, I believe all of you are ethical, or you wouldn't be on the call, right? You are ethical, and you try to do the right thing. But the problem is you don't realize that you're not legal in some areas. You don't know what you don't know, and of course ignorance is no excuse. The Federal Trade Commission doesn't give warning tickets. You know, every now and then if you get stopped by the highway patrolman on the interstate, every now and then they may just give you a warning ticket. The FTC doesn't do it, and this causes you to be at high risk for personal and family assets. So if you want to point fingers, who's the villain? The typical target most marketers point to is the FTC, but it's really this tsunami and the drill down we talked about a few minutes ago. So you need to comply, and our recommended solution that I promised to introduce you to at the outset is a membership in FTC Guardian. So what are the benefits? Well, the first one is you get a blueprint that makes your process of becoming compliant very simple and easy. And this is just a small clip of the beginning of the blueprint. Step one, learn what you need to know about the FTC. Well, after this presentation, you probably can check that one off. Step two, create the basic website documents and then proceed through the steps. We make it very simple and very easy, and the first way we do it is with a very simple and easy blueprint. And then, of course, you get done-for-you documents that would protect you right now. And if you look at this slide, you'll see categories. We have approximately 80 documents in our system right now. And if you look at the first two categories, basic website documents, and a couple of examples are terms of use and privacy policy. And, of course, that one has a lot of information about the remarketing, retargeting, and also the second one, supplemental documents, model releases for example, if you take videos of someone or a photograph and those persons are recognizable, you need to get clearance. And if you have a membership site, you need to have certain disclosures for the continuity plan. So there are a number of basic documents and supplemental documents for your website that go on your website. But then look at what you have there in addition, intellectual property protection documents. One example is a collaboration agreement. If you work with someone to create an ebook or a coaching program, how are those copyrights allocated and how is the revenue allocated? Also a non-disclosure agreement. And then 21 customer agreements. If you're a coach, we've got a coaching agreement, we've got a speaker engagement agreement among the 21. Very important to nail down your right to get paid for what you do, and also to limit your liability. Extremely important. And then 24 channel marketing documents, reseller documents for content. You can do white label, that sort of thing, JV agreements. So there's a massive amount of documents here that not only are your basic website documents, but they help you operate your business profitably and safely. And then you also get trust seal rights, a verified member logo that is displayed on your legal documents, which we believe enhances prospect confidence in what you do. And if someone clicks on that logo, they get this verification for the URL and the fact that you've signed on to our code of conduct, which again we think enhances confidence. And you know, one of the most fundamental tenets of marketing is know, like, and trust, and we believe this would certainly help you out a significant amount in the know, like, and trust area. Also, and this is one thing that really separates us, the easy to understand rules and strategies that need to be built in built into your business as you grow it, and these protect you now and also into the future. And most of these rules and strategies in the form of videos, and that's a clip of me, yours truly, there in one of these videos. And look at the topics that we have here. They apply probably to almost every one of you. The first one, of course, what you need to know. And you can, again, check that one off after this presentation. But website legal compliance, outsourcing. I mean, just about everybody, I'm sure, is outsourced, certainly probably once or twice at least to Fiverr and others who create maybe copy for your website, software for you, your website itself. You need to know that the work-for-hire rules are defaulting in favor of the contractor, meaning if you don't have certain magic words in your contract, then by default the contractor owns everything that you paid for. Using material of others, downloading, for example, photographs off Google, you need to understand what the copyright rules are, marketing agreements, online advertising, testimonials, and privacy and data security really focus a lot on FTC compliance, but then you have the intellectual property protection so that you can really protect the most valuable aspects of your business other than your list. And then this is something that we do that no one else does, and that is twice a month we have a Google Hangout on a new development or some very specific topic that we think is extremely important in the operation of your online business. And we respect your time here. We know you probably don't have time for an hour and a half chit-chat about this stuff. So we try to be very disciplined about me making a presentation on a Google Hangout for no more than 20 minutes. And then we have 10 minutes for follow-up Q&A, so a total of about 30 minutes twice a month for a total of an hour. And we believe that once you start the process of attending these Hangouts, a total of 1 hour per month for the two, that this is really at a minimum all you need to establish a process of building these strategies into your online business. Because if you do this consistently over a fairly short period of time, you'll start getting the hang of what we're talking about, and we relate these Hangouts to other materials on our website, so if they are related to what you're doing or plan to be doing, you know exactly where to go to find out additional information. So really, an hour a month is really all you need to get started right away with our very simple and easy process of compliance. Now, we've had a lot of really very, very positive testimonials about our platform that has the, the rules of the road and the documents, and you see the headlines here. We're not going to go through the detail, but we see great compliments on the website documents, easy to use, thank you, exactly what we needed. And here you see some very enthusiastic testimonials about our Hangouts. You see that first one was talking about who owns the work product on outsourcing. And you see there that this person is saying, I have another topic, please. We have a lot of suggestions from members about what they would like to see covered, and we do cover a lot of those. So we're very, very happy with the success of our Hangouts, particularly the fact that they respect your time. It's only about 30 minutes twice a month, and we're seeing a lot of very positive feedback from that. So, fair warning though, this is really important. By all means, you don't want to copy somebody else's website documents. It can be a copyright liability problem. One size doesn't fit all, particularly a privacy policy, because the privacy policy is supposed to reflect your specific marketing activities and the disclosures relating to that. And if you copy the other guy's policy, it's going to reflect those and not yours. And so you're almost guaranteeing failure to comply if you're copying somebody else's privacy policy. And by the way, as we know already, documents alone won't protect you. You've got to have the strategies, your own strategies, that you build in to your business. That was the first major takeaway that I asked you to write down at the very beginning. Now, I'm often asked to compare what our online membership program, our online platform, how does it compare to an internet attorney? Well, first of all, let's make it very clear. We always recommend that the attorney is your best option, always, because that's the only way to get a truly customized, very detailed customized solution. The problem is it's really expensive. For basic website documents, you would typically spend $2,500 to $3,000, and I get this from people who come to me who were quoted those figures from other attorneys. And then if you have a membership website where you have continuity plan sign-ups, another $2,000, that sort of thing. And then if you're getting into marketing documents at all and intellectual property protection, another $3,000. So it adds up in a hurry. And if you don't have this kind of budget, your only other option is to find an online service that you have confidence in that provides you not only the documents but the strategies that you can build into your business as you grow it. So as a recap, I think it's important to understand that in just a couple of minutes, I'm going to give you the financial information here, but suffice it to say right now, for less than 1 hour of my billable time as an attorney, if you were my client, you get access to this entire very simple and easy program and process, which includes the done-for-you documents, the strategies, and of course the access to live presentations with Q&A twice a month with Google Hangouts. A very simple and easy process, not a set it and forget it situation, but an ongoing process that's easy to implement, but it also keeps you up to date with what's going on and what the new requirements are. So I'd like to ask you rhetorically a couple of questions finally, and that is, what if your investment would save your business and family assets? Would it be worth it? Well, of course it would. That's ridiculous. I mean, we all would answer yes, but there's no way to know that if you become compliant through using our process, that it actually did save you from disaster. We can think that it might or probably did, but we can't be sure. But I would follow up with this question. What if all you can definitely point to as a result of compliance with our, that you would achieve with our solution is your peace of mind, and also if you're married, your spouse's peace of mind, knowing that you've taken reasonable steps to protect your family and the family assets, including your spouse's, right? What if that's all you could point to? Well, I would say, knowing my spouse, that it would definitely be worth it. There's no question about what my situation would be. So what will stop you from investing today in this process that will build your business, build into your business legal compliance? First of all, you don't like lawyers. If you don't like lawyers, there's not much I can do about it. I certainly understand why you might not, but I don't know how to respond to that one. However, if you believe that lawyers will harm your marketing, you're probably wrong about it, because contrary to popular opinion, lawyers are not going to point their finger at you, and certainly we're not going to point our fingers at you and say you can't do this. What we try to do is say what the risk is, define the risk, and there's certain areas where there may be a gray area where you can assume certain risk, but the important thing is it's a calculated risk. You understand what you're doing. You're not just a bull in a china shop, not understanding the risk and hanging yourself out, exposing yourself and not understanding why. So take calculated risk if what you want to. Our job is to point out the rules and the risk areas, and you as a business person, you make that decision. You might believe there's a lot to learn and it takes too much time. And if you believe that, you would be correct if you go about it the old-fashioned way. But we've simplified this stuff. I've spent a lot of time simplifying the document generation process. It's what I use every day in my law practice, and it's simplified. The rules of the road, the videos are broken down in 3 to 5 minutes videos, and of course the very simple and easy and quick hangouts that are live. So It is complicated, and it would take you too much time if you do it the old-fashioned way, but we've solved that problem. Trust me on that. And you're not sure it'll make a difference. I don't know how I can convince you that it will. I think if you stick with the minimal process, you know, the hour a month with the live presentations, and then use that to then link into other related information that applies to you in very short order, it will make a significant difference, in my opinion. Okay, so what does it cost? Well, the Pro membership consists of, you know, several elements. The videos, and you see the related values over there. Hangouts at twice a month, almost $1,500 because it's live and Q&A and all of that. The compliance documents, along with IP, marketing and professional, $500 or so each. So you're talking well over $3,000 for the real value, and the retail price on the FTC Guardian website right now today is $197 per year, right? Per year, not just a single payment. However, if you invest in the very limited time today, it's really only a single payment of $197 for life, fully paid. So that includes all the documents, all the updates to the training that we put in there, all of the hangouts that are twice a month. Once you pay the $197, you're done. And again, this is less, significantly less than 1 hour of my time if you employed me as an attorney for this entire set of resources, tools that have been simplified for you. And in just a minute or two, Alan is going to explain exactly how much time you have to reply and to take us up on this very limited time offer. And I'm going to suggest to you that now is probably definitely the best time. In fact, there never, in my opinion, ever has been a better time to act than right now. And here's why. Remember at the very beginning, I asked you to write down what I think is the single most significant overarching takeaway from this presentation, and that is successful marketing strategies, which is what we're thinking. I mean, that as marketers, that's what we think about almost all the time, right? Successful marketing strategies reflect built-in legal strategies, and if they do not, you're flying blind, and you're definitely asking for trouble, and you're probably an open invitation for some kind of FTC trouble down the road, hopefully not too soon. So you need to start beginning today to build in these strategies as you grow your business. What you don't want to do is say, well, I'm going to put it off, and when I get to a certain plateau next year, then I'm going to start thinking about the legal stuff. The problem is you've built your business, you've added funnels, you've done all these things in this period of time that you've procrastinated, right? And you should have been building in the legal strategies along the way. So that's the fallacy of not starting now. And remember, the second bullet, set it and forget it, is an open invitation. The gorilla isn't going to wait for you to become legally compliant. You need to start right now with that 1 hour a month, and then following that simple and easy process. And really, if you just forget about the rest of it, this is really what it comes down to. There's just too much at risk to procrastinate. Let's say you're like me. You're on the interstate highway, and the posted speed limit is 70 miles an hour. And you're thinking, I'd like to get there a little quicker. So if I set the cruise control on 75, you know, maybe it's okay, right? I can take a little risk here. And you're probably wrong. I'm probably right, because I've done it some, right? And the chances of getting caught are slim. But if you do get caught, so what? It's a fine of what, $100, $150? You can handle it. The problem with the FTC and operating your online business is that it is a life-changing event. I mean, you can be saddled with a massive debt for the rest of your life that you cannot file bankruptcy for. So that's personal liability and family assets. And there's no way to know how likely it is to happen to you. That's a function of what you do and possibly what the FTC is looking for at any point in time, and we don't know what that is. So maybe it's not likely, maybe it is, depending on circumstances. But if it happens, the consequences are so bad, you just need to take steps, assuming they're simple and easy, which they are, to prevent it. So my final promises to you are these. When you invest today, you'll be happier because you'll feel a real sense of relief that you finally understand what the guerrilla is all about and how to manage the guerrilla. And you'll feel more successful because you'll actually have the tools and the process to actually tame this guerrilla, and you'll feel much more freedom because you won't worry. You'll be able to stop worrying about protecting your assets and focus on what you really do best, which is growing your business, or you'll get your money back. We have a full 30-day, no questions asked money-back guarantee if you don't realize these promises I'm making to you right now. So this is the last slide here, and it's just a reminder that for a single payment of $197, you get lifetime access, and this is the link that you need to go to. And be sure to write this down, but hang on to the call, because I know Alan has some very important information for you, including, not the least of which, is how to get access to the free book. And I think David has something for you as well that might well be worth your while to hang around and see what that is. So write down the link at the bottom, ftcguardian.com/NAMS, N-A-M-S, and then now I'm going to be turning it over to Alan for his information.
Alan, can I say something while you do that?
Yeah, you please do. I'm going to mute my mic so you don't hear me typing, okay?
Yeah, the reason I wanted to say something was because I jumped on this when I met Chip a couple of years ago. Actually, I don't think it was that long. It was like a year and a half ago. And I jumped on this because there was one aspect of this tool that I thought was brilliant. And Chip, I'm going to tell you, for me, it was that it was a generation tool, not a template tool. So it was that you actually built custom documents based on my input. And you and I have done a webinar before about this. And during that webinar, while that webinar was in play, we were within the 1 hour that we were talking, I was actually able to go through and build all of my documents before the webinar ended. It was that simple. So I was really excited about this tool. Still am. Still use it.
So, can you hear me?
I can now.
Okay. While Alan is continuing to get his questions and answers sorted out, let me just speak to your point, David. I'm trying to figure out how to explain this without taking too long. The process involved in the generator that you just referred to is generally referred to as rule-based document assembly. Right. Meaning that the document itself, let's say that you're talking about terms of use, for example, or a privacy policy. The document itself doesn't exist as a document. There are, considering all of the documents in the system, there's probably 10,000 or more separate clauses in a massive database that I created, right? Mm-hmm. And you answer questions that I have also created that are linked to these clauses. So you answer the questions. If you don't quite understand what the question is all about, sometimes there's a little video or there's help text to explain it, and then you answer the questions. And sometimes the question that you're answering is dependent on the answer to a previous question. So there's all sorts of branching logic that you really can't see underneath the system, right? So when you get through answering the questions, then the software engine goes to the database and pulls out all the clauses that are indicated by your answers, and then it assembles them in the right order, and then it numbers them and generates a document from scratch. And so the result is a much more customized document than a template can produce.
Mm-hmm. Right? And that's what I loved about it, because I knew that when I was going in and doing my question and answer, that you were actually building a document from scratch for me and for my website. So I was completely confident that it was totally mine.
Right. And Also, the process of answering those questions that the generator raises, right, is very similar to what you would do if you employed me as an attorney, right? Because, you know, if we're talking about a privacy policy, guess what? I would say, okay, I've got a bunch of questions I want to ask you, right? So I would ask you questions, and, you know, we would go through the process, and then based on answers and some advice by me, then I create the document. So the software replicates to the extent you can. It cannot replicate exactly what an attorney does, right? It doesn't have judgment, which an attorney does. But it comes fairly close to replicating what an attorney actually does, and it generates a document far more customized to your specific requirements than a template would.
And the other thing that you told me, and then you even alluded to it today, was that this is the exact engine that you use when you deal with your clients at your higher hourly rate.
Yeah,
So,
I mean, I created this back, I think I may have told you this, David, back
did.
in the early 90s when I was doing a lot of very complicated software distribution documents, some of them with 30, 40 pages long, right? And I was doing cutting and pasting, and it was driving me crazy. So a client of mine, a software guy, sort of helped me design this thing, and he created it, and it worked. I mean, it was the difference between taking an axe and trying to chop down a big tree or putting a massive power saw to it. I mean, it was like it automated this process. And then another client to me said to me, why don't you make a product out of it, which I did in the mid to late 90s or right before 2000. And so it is exactly what, as you say, it's exactly what I still use every day in my law practice. So it's not some stuff that I cobble together to sell on the internet. It's my law practice tool that I'm licensing at an extremely low cost.
and the other thing is that it evolves. I mean, this thing has evolved over the last year amazingly. You've added so many new document opportunities to this. The speaker, I'm looking at it, I didn't even know there was a speaker engagement in there now. I've got to go get my speaker engagement contracts out now. So now that we have it available, I can go do that.
Well, one of the things I've tried to do is to add documents in this last year or so, as you indicated, that reflect more than just a pure internet marketer. For example, documents that fit the needs of speakers, authors, coaches, consultants, and general entrepreneurs, right? They have needs that are a little bit different than just a pure internet marketer. So I've tried to branch out and cover all of those bases, particularly with respect to customer agreements for all these different types of online businesses. So that's the area that we have really added a lot to in the last year or year and a half.
Mm-hmm. Well, I've been just tickled to see it. So thank you so much for keeping it up to date. And I continue to use it and continue to tell everybody I know that this is the only legal tool that I recommend. So, you know, well, thank you so much.
I appreciate those kind words, David. And one thing I'd love to see you do is see you your name on the on the attendee list for one of our hangouts. We've got one coming up, I believe, next Thursday for members. So people who invest tonight in this offer certainly will be available for that one because we have a lot of fun there. I do my presentation, but it's not too long. It doesn't get too boring, right? We have Q&A. Some of it's just fun.
Is it at the same time every week?
It's usually a Tuesday or Thursday evening, and it's always at 8 p.m. Eastern.
Okay.
So by 8:30, you're out of there. You haven't ruined your evening, right? You haven't, you know, to sit down for an hour and a half for a long presentation takes a lot out of me. I know that. But this one, pretty quick in and out. It really helps you keep up. And, you know, we'd love to see you there. So,
okay, great. I do have a question for you about
what's
this.
that?
Because you brought up earlier a couple of times, you talked about affiliate marketing and you talked about coaching. And the coaching thing perked my ears up pretty well there, because how does claims about coaching get people in so much trouble?
Well, here's one area, and we covered some of this in a hangout last week, and that is confidentiality, right? Let's say that you're the typical coach, and some of what you're coaching is sort of common knowledge, right? Mm-hmm. But some of it isn't. Some of it would be maybe pieces of information that are common knowledge, but the way you've combined them into a solution or a strategy is somewhat unique, right? And so what you don't want is for your client to be taking your information and then publishing it.
Sure, okay.
Right? So one of the significant portions or elements of your consulting agreement or coaching agreement is the confidentiality section,
sure,
right? And in the confidentiality section, you're interested in only two things. It's really pretty simple. What does the client have the authorization to do, or how does the client use your information, your coaching, your solution, your strategy? Mm-hmm. And then what limitations are there on the disclosure of this, right? So you basically are saying that the information is confidential. It can be used only in your internal operation of your business, right? And it's not for resale or republication, right? So that's the restriction on disclosure. So that's a big one, because we've seen a number of cases where those clauses were not in the coaching agreement, or there wasn't even a coaching agreement at all, right? Sort of a handshake deal. So there's no confidentiality, and the coach is in a position of possibly losing these confidential information rights. And then another one is limitation of liability, because any user of your strategy or information that you're imparting as a coach could end up costing them money, costing them damages. Something can go wrong, right? So let's say you get paid a few $100s or a few $1,000s for the strategy and the series of coaching sessions, but you end up getting sued for $100,000 because of some loss, right? Mm-hmm. So that's a bad business deal, to be paid $1,000 but be subject to losing $100,000, right? So one of the most significant points is limiting your liability to usually to the amount of fees that you've received. And that's not going to be the case unless you have a clause that does it and does it correctly. Mm-hmm. Mm-hmm. So confidential information, limitation of liability are two of the most significant things that a coach can do.
Now, if people missed those things on your Hangouts, do you have an archive of Hangouts in the membership site?
I'm so glad you asked the question.
I'm back. I love questions like that, right?
Well, let me finish this one, though. This one's a good one. We've got a certain base of information we call rules of the road, and I covered that a little bit in the presentation. You saw the topics, mm-hmm. and most of that is in the form of various videos in those categories. Some of it is cheat sheets, which are bullet point type summaries of rules, right, and strategies. Mm-hmm. So that's there as a base. And then sitting on top of that would be the 2 Hangouts a month, which involve new developments and also certain aspects that are really critical. So the Hangouts supplement the base. And this is one thing I'm leading up to, only last week we decided that all of a sudden we were getting a lot of information in here, right? Mm-hmm. And so we came up with a tag system similar to Evernote.
Excellent.
So I went through and tagged everything so that you can now do searches, and you can see that we've got 3, for example, 3 5-minute videos in various sections of our base rules of the road, and we have 2 Hangouts that also deal with the same topic, and it pops up right there when you do the search. So it's very, very easy to target the information that you're looking for.
I know why you're excited to tell us about that, because that's a ton of work. I've done a lot of that myself in our Facebook group.
I want to make sure everybody, we've got a lot of people that are still on the line. I want to make sure people get a copy of Chip's book. So Chip, if you're okay, I'm going to change the screen back over to me real quick. Are you good with that?
I'm good with it.
Okay. So I'm going to show my screen. You guys see my screen?
Yep.
Okay. If you want to get a copy of Chip's newest book, and again, I believe it's what, 4 books, right, Chip?
Yes, this is the latest of 4.
The four, and specifically all of them, specifically on internet, SaaS law, and being FTC compliant and stuff like that. So the latest book, if you want to get a copy of it, you'll get a PDF copy of it if you send an email to support@FTCGuardian.com. And the subject line, this is just and just so you know, this is just like one of those little, it's not even an autoresponder. It's like a Google, if you see this, send this thing.
It's like a vacation canned response.
Yeah, a canned response, exactly. That's what I'm trying to say. I don't want people to think that they're opting into another list or anything like that. I want to be, transparent. It's just, that's what it is. It's a canned response. So if you put this in the subject line, you send an email to support, you put this in the subject line, you're going to get a reply from me that says, go here to get the download for Chip's book, and you'll also get a link to CreateSpace and a coupon code where if you'd like to actually purchase the book, you can purchase it. The book sells for $24.
$24.95.
$24.95. And if you use the coupon code, it's like $3.95 or something like that. So you'll get a free PDF of it. And if you'd like to actually have the hard copy of the book to read, then you get a coupon code for that as well, and you can purchase it there. So just send the email, and you're good. We just had a ton of questions. I really enjoy doing webinars where I get so many questions, because while Chip is doing his what I call a legal beagle presentation, I get to answer questions and get to talk to people. So it's like you don't hear me because I mute my mic, but I get to interact with people and talk about what's going on and stuff like that. So, and tell them what we have. So let me just go. The next slide is, if you're interested, it's one payment, $197, and if by chance you purchase with the annual, I'll make sure it's good. It's ftcguardian.com/NAMS, and I believe David had a little bit to add to that. So
I did.
Let me jump in, if I may, before David adds his to this. How long is the offer going to stay up?
We normally, when we do a promo with someone like David or whatever, it's like a 4 to 5 day period. So say 5 days, because what we do is, and I'm being totally transparent, people. It's the only way I know how to be, is we do the webinar. We'll put the webinar up for those people who didn't have the opportunity to watch the webinar. And usually we put like a 5-day timer on it. And specifically, and this is from a marketing standpoint, if any of you are marketers, I use a 5-day timer. And the reason I use usually a 5-day timer is because it covers a weekend. So if you're doing webinars and stuff like that, you want to make sure that you at least cover over a weekend. So if people have some time, they can watch it over the weekend. So I cover the weekend, and we make sure that you're able to do that. Other than that, it's $197 a year, no questions about it. And
yeah. All right, so let me tell you what I'm giving away for anybody who is still on tonight. We're going to give them the Found Money course that we have. That is namspassiveincome.com, namspassiveincome.com, just like it sounds, all one, no spaces or anything, namspassiveincome.com, and use this coupon code, FTCGuard, FTCGuard, 100% discount on that $197 course. So just for attending tonight, that's what you're going to get.
Wow.
From me.
Wow. Thank you, David. That's terrific.
You bet. So guys, listen, this was awesome, and I love this tool. I just wanted to make sure that you know that this is one of my top 10 tools. So this is one of those things that I don't think we can do without. And to tell the truth, if I didn't have it, Chip, I think I would actually lay in bed well, I think I actually did consider closing down my business, because to tell the truth, the risk is huge without this tool.
Well, all I want to say is thank you, both Alan and David. Appreciate everything, particularly David for sponsoring the Hangout, his terrific group, and for his additional contribution just made. And I'm looking, while Alan's talking, at some of the questions in the chat box. And again, I'd like to say, if you still have questions, send an email to support@ftcguardian.com, and we'll get you an answer by email.
Thank you. Look forward to having you inside our member area, and if we can help, it's basically support@ftcguardian.com. We're here to help and to make sure everybody stays safe out there. All right. Thank you, everybody.
Thank you.
Good night.
Bye-bye.